Good afternoon and welcome to today's webinar. This is Shannon Farmer and I'm joined here today by my colleagues Bill Kennedy and Ashley Wilson. We welcome your questions during and after the program, but we may be limited as far as timing. So feel free to submit questions via the Q&A box or to email them to us directly after the program. If time allows, we'll answer questions during the webinar. If not, we'll follow up with you directly after the program. We've circulated the slides in advance. We'll also be sending the slides along with a recording of the webinar as a follow-up. Today we're going to be talking about the changes that are going on with the NLRB, and what every employer needs to know. So we're going to first talk about the NLRB and its current composition. We're going to talk about unfair labor practices in the non-union workplace. Traditionally, in the past, a lot of people have thought, I don't really need to worry about the NLRB if I don't have a union. And under the current NLRB and over the past 7 years, that really has not been the case, as the NLRB has taken a very active role in non-union workplaces. So we're going to talk about that. And then we're going to finish up with an update on recent NLRB rulemaking and what it means particularly for non-union employers. First thing I want to talk about is the current composition of the NLRB. And before we talk about the details of the composition, I want to give a little bit of background on the NLRB and why this matters. So the NLRB is the agency tasked with overseeing enforcement of federal labor law. It covers nearly all private sector employers outside of a few excluded industries, but it generally does not have any application to public sector employers. The NLRB is a somewhat unique federal agency in terms of its composition and the fact that it has both an investigatory and prosecutorial role. Currently, there are 5 members that have staggered terms, 3 of which are from the majority party, 2 from the minority party, and it's set up that way with this sort of political tension. It needs a quorum of 3 members to act. Now, the NLRB, when, for example, an unfair labor practice charge is filed, will investigate the allegations, and if it concludes that there's a basis for the charge, it will then issue a complaint. Then the NLRB itself will prosecute that charge in front of an administrative law judge that works for the agency. So the agency is the investigator, the prosecutor, and the judge. Then the ALJ, administrative law judge, decisions are appealed to the full NLRB. So it's the investigator, the prosecutor, the judge, and the initial level of appeal. After an NLRB, the full NLRB issues a decision. It can then be appealed to the United States Courts of Appeals, either in the area in which it arose or for the D.C. Circuit, which is where most of those appeals go. This process often takes years, and so it can discourage employers from pursuing appeals, even though in recent years the courts have looked with suspicion at many of the decisions coming out of the NLRB. Unlike most agencies, and this is very significant when we're going to be talking about some of the things that the NLRB has been doing, traditionally, the NLRB does not have the same kind of respect for past precedents issued by the NLRB that other agencies might or that courts do. The board regularly overturns decisions that are issued by prior boards that have different political compositions. This is something that the federal courts of appeals have in fact faulted the board for and has led to some appellate courts refusing to enforce NLRB orders where the board has flip-flopped on these issues of law. Now, the NLRB has come under a lot of fire in recent years because many believe that it has been taking a very activist role in federal labor law and in the relations between private sector employers and their employees. In response to that, yesterday, Senate Republican leaders introduced a bill called the NLRB Reform Act, which would make major changes in the NLRB aimed at reducing what is seen as its overly political agenda. One of the things that it would do is increase it to 6 members, and that would be an equal composition of Republicans and Democrats. In order to take action, the board would have to have 4 votes. So that means that all actions by the board, be that a decision on a case, a new rule, or even certain kinds of administrative decisions, would have to be bipartisan. They couldn't just be taken by the members of one political party as they can be now. Also, the decision to issue a complaint, which right now there's no ability to get review on at that stage, would be reviewable in federal court before the ALJ hearing, which is essentially a trial, is held, and the parties would have the ability to get discovery on the NLRB decision-making process and its issuing of a complaint. So before an employer had to go through the entire trial, then get its appeal before the board, which can take years and significant attorney's fees, and then appeal to the U.S. Courts of Appeal, it would have the opportunity under this bill for federal review of whether there was a valid basis for the complaint. This could be very significant in cases where the courts and the NLRB's view of things disagree. For example, in recent years, the NLRB has taken the position that private arbitration agreements, so not an arbitration in a collective bargaining agreement, but a private arbitration agreement that has a class action waiver is a violation of federal labor law. The courts have not agreed with that. So if the NLRB were to issue a complaint saying that the arbitration agreement was invalid under this bill, the employer would have an opportunity to go to federal court and most likely prevent that trial in front of the ALJ from ever happening. In addition, under the proposed bill, cases could be appealed to federal court if the NLRB hasn't decided it within 1 year. That would really streamline and speed up the appeals process, and to encourage the NLRB to act more quickly, it would provide for funding cuts if it doesn't decide 90% of its cases within that year. So this would be a very significant change. Obviously, with it just having been introduced yesterday, it's far too early to predict what may happen with that bill, although I can't imagine that it would be acceptable to the White House in its current form. Now let's talk about what's going on with the composition of the NLRB, because there's been some very significant developments in that in 2014. In a unanimous Supreme Court decision, the U.S. Supreme Court held that President Obama exceeded his constitutional authority to make recess appointments in a case that's generally referred to as null canning. And as a result of that decision, 3 recess appointments were invalidated. Now, this is really significant because there had been a previous Supreme Court decision, New Process Steel, which said that all the cases that were decided when the board did not have a 3-person quorum were invalid. So as a result of null canning, all the cases that were decided by the NLRB when it didn't have at least 3 validly appointed members were voided. And that's in excess of 200 cases, as well as certain administrative decisions. The administrative decisions that were made have since been ratified by the board, and the cases are working their way through the board. However, given the current composition of the board, which we'll review in a second, it's unlikely that there are going to be significant changes in the outcome of those cases. The question is whether the board will be able to review and reaffirm all of those decisions that were invalidated by null canning before the end of the current administration, and potentially, obviously we don't know what will happen in that administration, a change in the composition of board and or political party depending on the results of the presidential election. So it's yet to be seen what the impact will be. Certainly in the meantime, many controversial decisions were overturned by the null canning decision, and they have not yet been reaffirmed. So employers are operating under the previous legal standards. We really don't know yet when some of those decisions will be put back into place, because there were some really landmark decisions. And it's a very uncertain time for employers when you're waiting to see what the board is going to do with many of these decisions. So after the Supreme Court's decision in null canning, the challenged recess appointees were no longer on the board, and they were replaced by appointees who were confirmed by the Senate. So for the first time in the Obama administration, the NLRB actually has a lawful composition, and you see there's 5 members, all of whom have been confirmed. The first of those terms to expire is going to be of Board Member Johnson, and that expires in the summer of 2015, and there's another one expiring Board Member Hirazawa in 2016. Those are the two that are going to expire during the current presidential administration. We give a little bit of background on these appointees, these board members. Mark Pierce is the chairman and has been since August of 2011. He's been on the NLRB since March of 2010. Lauren McFerrin, formerly the chief counsel for the Senate Committee on Health, Education, Labor, and Pensions. She was previously in private practice. Kent Hirazawa, another Democrat, was chief counsel to the chairman of the NLRB before he joined the staff. Previously, he was in private practice, and before that, he was actually a field attorney for the NLRB in the 1980s. Harry Johnson was a partner in private practice and was a well-known labor and employment attorney. And Philip Misamara was, again, in private practice and has a Pennsylvania connection, having been a senior fellow at the University of Pennsylvania Wharton Business School. So you see a mix of experience, and I think if we were to look at the biographies of these board members compared to some of the recess appointees, I think you see, at least in some of the nominees, a slightly less overtly union-sided background because they had to make it through Senate confirmation, and so that made them, I think, perhaps a little more centrist than some of the, the recess appointees. And with that, I am going to turn this over to Bill, who is going to talk about unfair labor practices in the non-union workplace.
Thanks, Shannon. I just want to give a little bit of background to what we're talking about. I am going to talk about employees' use of email and confidentiality policies, and Ashley Wilson's going to talk about social media cases and subpoenas for employee handbooks. And all of those topics are topics that were subjects of recent NLRB cases and really cases that highlight the NLRB's recent focus on the non-union workplace. A little bit of background on the unfair labor practices. Section 7 of the NLRA protects employees' rights to engage in protected concerted activity for mutual aid or protection regardless of union membership. The NLRB has defined mutual aid or protection to include efforts to improve terms and conditions of employment or otherwise improve employees' lot as employees. And concerted activity is conduct or actions engaged in with or on the authority of other employees and not solely by and on behalf of the employee himself. And those are ideas that have not changed under the current board structure, but how those things are applied to employer policies and the workplace have changed pretty drastically recently. Section 8A1 of the NLRA prohibits employers from engaging in conduct that would interfere with, restrain, or coerce employees in the exercise of Section 7 rights. The boards held that this prohibition extends to any policy or rule that would reasonably tend to chill employees in the exercise of Section 7 rights. With respect to employees' use of email, in December 2014, the board issued a decision in a closely watched case regarding an employer's policies governing employee email use. And that case was Purple Communications. In Purple Communications, the board explicitly overruled a 2007 decision called Register Guard regarding employees' use of employer email systems. In that 2007 decision, the board held that employer email systems are just like other communications-related equipment, like employer bulletin boards, telephones, and other types of communications equipment in the workplace. The board also held that employers are free to ban non-business related use of that equipment, just as employers are free to regulate the use of bulletin boards and other communications related equipment. In Purple Communications, as the slide says, the board changed course, explicitly overruling Register Guard. In that case, the policy at issue, the employer policy, banned the use of the company's computer, internet, voicemail, and email systems for non-business purposes. Again, prior to this decision, such a policy was presumed to be lawful. Three-member majority in Purple Communications rejected the 2007 holding in Register Guard, instead finding that employees who have been given access to an employer email system for work have a statutory right under the Act to use that system to communicate for all statutorily protected purposes during non-working time. And that includes union organizing, it includes other types of protected concerted activity. The board adopted a presumption that rules banning non-working time use of email are unlawful. The board did state that employers can rebut the presumption if they demonstrate special circumstances, although based on the board's decision and other decisions issued by the board, we believe that that's a very difficult standard to meet. That will be a very difficult standard to meet. The one positive that comes out of this decision is that the board did confirm that employers may continue to monitor employee use of email for legitimate management reasons, and to inform employees that they have no expectation of privacy in their use of employers' email systems. But the board did remind employers that the monitoring cannot be done in a discriminatory manner. Some practical considerations to think about are that employers should be aware that employees who have been given access to an employer's email system must be allowed to use the email system to engage in protected Section 7 communications during non-working time. An employer is not obligated to give employees access to an email system if the employees do not already have access to the system. But the employer cannot ban access to the system for employees who do currently have access to the email system. One issue that remains to be decided, one kind of tricky thing, is that it's easy to decide when a sender is on non-working time. Somebody who drafts an email can draft an email on non-working time and send it on non-working time. But if that email has 50 recipients, how do you determine whether the recipients are on non-working time when they receive, open, and read that email? And that's something that may be fleshed out. Shannon has something to add?
I was just going to jump in and say that we got a question about whether Purple Communications affected the board standard announced in Register Guard about what is a beneficent act. So for many years, the board has had a principle, and this relates to limitations on solicitation and distribution. You, as an employer, have the right to limit employees' solicitation of other employees and distribution of materials in your workplace so long as it's done consistently, and there's different limits for solicitation and distribution. But there has been an exception to the general rule that if you allow non-work-related solicitation of your employees or distribution of materials, then you can't exclude the union. There has long been an exception that says an employer can permit a small number of beneficent acts. So the idea being that if you allow, for example, a United Way campaign to come in and solicit your employees, that doesn't mean that you have to, on working time, that doesn't mean that you have to allow the union to come in and solicit your employees on working time. So the question was, did Purple Communications change that standard for what the beneficent acts are? And the answer to that is no, it did not deal with that issue at all. So the general ruling about discrimination against unions as it relates to solicitation and distribution, and the exceptions for a small number of beneficent acts are unchanged by this decision. This really only related to when you can just exclude employees from using work email for non-work purposes.
And that's right, Shannon, but the thing that's more remarkable about this decision is that it essentially says that employees who have access to the email system, even if for only business purposes, now have access to the email system for Section 7 activity during non-working time. And that is a pretty drastic change from, obviously, a pretty drastic change from the Register Guard standard. Again, employers may limit the types of communication during working time and may continue to monitor employees' use for legitimate business reasons. But, and I'll talk a little bit more in a few slides about employer policies, but if you have an electronic communications or email usage policy, whether it's in a handbook or not, you really need to go back and look at that policy. A policy that was compliant with board standards and the law in 2013 may not be compliant with the board standard and the law in 2015. So it's really important that you go back to review those policies. Next, I'm going to talk about confidentiality policies, and there are a few pretty recent cases from the board that deal with employer confidentiality policies. Again, both union and non-union employers must carefully craft confidentiality and data protection policies to comply with the new board standards. In a case called Fresh and Easy Neighborhood Markets, a case that's actually received more attention because the board found that an employee engaged in protected activity when she asked coworkers for witness statements and their support in her sexual harassment complaints in the workplace. In that case, the board also held that a confidentiality section of an employer's code of conduct that instructed employees to keep customer and employee information secure and to use it only fairly, lawfully, and for the purposes for which it was obtained was unlawful. The board found that that policy violated Section 8A1 of the Act, explaining that employees could reasonably or would reasonably interpret the rule to provide that all employee information is confidential and the disclosure of that information the limitation on disclosing the information only for the purpose for which it obtained would chill employees' rights to share information about one another. In Phillips Electronics, the board ruled that an employer who maintained an unwritten rule that discipline is confidential and that prohibited non-union employees from sharing or discussing their discipline and from sharing or discussing discipline with their coworkers was unlawful. In Phillips, an employee received discipline for performance problems and for harassing behavior toward a female coworker. After receiving a written warning, the employee complained to coworkers, further harassed the coworker, and showed the female coworker who complained about him, and showed coworkers a copy of the discipline. The employer terminated the employee, and in the termination documentation stated that he was being fired for, among other things, sharing a confidential discipline form. The board stated that an employer violates Section 8A1 when it prohibits employees from speaking with coworkers about discipline and other terms of employment, absent a legitimate and substantial business justification for the prohibition. The good news is that the board did uphold the employee's termination for other reasons, but the message to employers was clear that employers may not, barring a compelling business reason, prohibit employees from discussing disciplinary actions with other employees. The last case I'm going to review is called Quicken Loans, which is another 2014 decision in which the employer required in which the board reviewed an employer's policy that required non-union mortgage bankers to execute an employment agreement that contained a confidential information provision. The policy the agreements prevented the employees from disclosing non-public information, including personal information of coworkers, such as home phone and cell phone numbers, addresses, and email addresses. An administrative law judge found the confidentiality provision substantially hindered the employees' exercise of their rights, which included discussing terms and conditions of employment and other employees' contact information. And the new board affirmed the administrative law judge's conclusions. So there are some pretty clear messages to employers related to that come from these confidentiality policy cases. If you have policies regarding email, computer usage, or confidentiality or maintaining the confidentiality of company or employee information, whether those policies are in a handbook, they're standalone policies, or they are unwritten policies, you need to review the policies for compliance with current board precedent. And remember that these decisions apply in the union and non-union context. Keep in mind that provisions containing ambiguous terms should provide examples of the type of conduct or speech that the policy is lawfully intended to restrict, and you should consider including a disclaimer that the employer does not intend to infringe on employees' Section 7 activity. And with that, I'll turn it over to Ashley, who's going to talk about social media and subpoenas for employee handbooks.
Thanks, Bill. Over the past 6 months, there have been several decisions where the board has considered restrictions on employees' use of social media. The board continues to try to expand its interpretation of the forms of employee online behavior that constitute protected concerted activity under the Act. In the first case, Triple D LLC, doing business as Triple Play Sports Bar, the employer in that case is a bar and restaurant. And when the employees learned that they owed more money in state income taxes because of withholding mistakes made by their employer, the employees complained about it at work. And in response, the employer planned a staff meeting to discuss those concerns. Now, before the staff meeting occurred, a former employee posted on Facebook, maybe somebody should do the owners of Triple Play a favor and buy it from them. They can't even do the tax paperwork correctly. Now I owe money, WTF. And a current employee then commented on that post, I effing owe money too. Another commented, I owe too, such an a-hole. And then another employee liked the post. Now, previously, to determine whether an employee loses the Act's protection, the board employed a balancing test under Atlantic Steel. And Atlantic Steel stated that 4 factors need to be considered. First of all, the place of discussion. Second, the subject matter of discussion. Third, the nature of employee's outburst. And fourth, whether the outburst was provoked by the employer's unfair labor practice. In this case, the board found that the Atlantic Steel framework, and particularly the place of discussion prong, is not well suited to address issues which arise in the off-duty and off-site use of social media. Rather, the board said that Atlantic Steel is better for workplace confrontations with the employer. Ultimately, the board determined that both the employee's comments and the like in response were dialogue between employees about working conditions. Therefore, they were protected by the Act. Specifically regarding hitting the like button, the board concluded that the employee engaged in protected concerted activity, and it explained that hitting the like button expresses agreement with a coworker's original complaint and thus is protected. As it relates to the comment that the employee made, the board rejected an argument by the employer that the comment was so disloyal that it lost the protection of the Act. The board explained that the comments had been made pursuant to an ongoing labor dispute, were not directed to the general public, and were not so disloyal so as to lose the protection of the Act. The next case, Richmond District Neighborhood, it was a switch from the board, and the board tried to distinguish this case from Triple Play. Richmond District involved a teen center and 2 employees planned for insubordination. Now, this plan started at the close of a school year, and the employees of the teen center anonymously submitted pros and cons of working there. And then before returning to school, the 2 employees engaged in Facebook posts where they responded to the phrase, rather than follow the center's policies, they would, and some of their comments were, let's do some cool SHIT and let them figure out the money, field trips all the time, play music loud, teach the kids how to graffiti up the walls, we'll take advantage, etc. In that case, the board found that the Facebook conversation was so egregious in its pervasive advocacy of insubordination that it lost the act's protection and rendered the employees unfit for further service. Now, in this case, the board was not concerned with the employee's use of profanity. Rather, the board focused on what it felt was a plan by the employees to engage in a disruptive pattern of insubordination. The board explained that the magnitude and detail of the insubordinate acts advocated in the post reasonably gave the employer concern that the employees would act on their plans, and they felt that this was a risk that a reasonable employer would refuse to take. Some practical considerations for employers. Absent some evidence of the magnitude and detail present in Richmond, employers should assume that an employee's use of social media to discuss wages and working conditions will be found by the board to constitute protected concerted activity. This use of social media is not limited to Facebook. It also applies to Twitter favorites and retweets, and also to Instagram likes. Therefore, employers should carefully weigh the risks of disciplining or discharging an employee for engaging in this type of activity. The next case that we're going to look at discusses subpoena for an employee handbook. In Allied Waste Service of Massachusetts, the regional director issued a subpoena to an employer for the employee handbook. The employer refused to comply with the subpoena and filed a petition to revoke. In considering the employer's petition to revoke, the board found that the regional director had articulated a legitimate position. Therefore, the board denied the employer's petition to revoke, explaining that the subpoena was potentially relevant to the unfair labor practice charge under investigation and described with sufficient particularity the evidence sought. The board stated that the standard of relevance applicable to subpoenas is extremely broad. Therefore, although the two pending charges did not allege a violation based on the language in the employee handbook, the board found that the regional director stated a legitimate position that the handbook could shed light on the articulated non-discriminatory reasons for the alleged unlawful discharge or could relate to the disciplinary process generally. Just some practical considerations. As Allied Waste instructs, subpoenas for handbooks are valid. Therefore, as long as the articulated reason for requesting the handbook is potentially relevant to the unfair labor practice charge, it will likely be granted. Now I'm going to turn it back over to Shannon. She's going to give us an update on NLRB rulemaking.
And before I do, I'm just going to add one thing on this issue of NLRB subpoenas. So as an agency that doesn't really have its own enforcement power, when an employer refuses to respond to an NLRB subpoena, the NLRB then can go to federal court to get a enforcement of that subpoena through a court order. And in doing that, there's recently the courts have affirmed that the review of that the courts will give is very limited. Basically, if the subpoena relates to something that is within the authority of the NLRB, they will enforce that subpoena. So things like relevance are generally not going to be accepted as objections to the subpoena, and that's something, it may be something, you know, it may not be admissible in terms of the hearing. You may have certain kinds of defenses, but the courts give pretty wide latitude to the NLRB in terms of enforcing their subpoenas. So that's something to be aware of when you're in an action with the NLRB, when a complaint has been issued. They will be given pretty broad discovery. And now I'm going to move on to talk about update on some recent NLRB rulemaking. We noticed that some people have been sending questions. That's great. Please feel free to send them, and we will respond to those that we can at the end of this section, or we'll respond personally after the presentation. So big news in recent months with the NLRB has been their issuance of a final rule referred to colloquially as the ambush elections rule. It's expedited election procedures. Employers call them the ambush election rules because they feel ambushed by the NLRB and these petitions. They were issued on December 14th. They are scheduled to take effect on April 14th, 2015. So they are not yet in effect. This is the time, though, as an employer to get ready, and we're going to talk about some of how to do that. We'll also in a minute talk about the fact that there are some legal challenges that are pending, so it is possible that they could be delayed, that enforcement, or potentially even not go into effect at all. But the gist of the rule is that it allows employees and unions to significantly shorten the time between filing a petition and the union representation election. You can think of this for people who were following the discussion about EFCA, the Employee Free Choice Act that was going on in 2008, 2009, in that time period, about the impact that it would have on employee unionization efforts. This has been described by some people as basically EFCA light. So it doesn't have the abolishing the independent election the way that EFCA did, where you could just have the automatic recognition, you could get rid of the secret ballot election, but many of the things that EFCA was trying to do in terms of making it easier for unions to organize, speeding up the process, because unions complain that the cards are stacked against them when the employer has more access to the employees, and the employer gets to delay the process by bringing what the unions would term frivolous legal challenges. So this is an effort by the NLRB to eliminate what the unions believe are barriers to unionization efforts through the election process. So this really limits the ways in which the employer can challenge things like the appropriateness of the unit that the union is petitioning to represent. So to step back for a second and talk about the process, a union will get cards signed by employees to create what's called a showing of interest. In order to petition for an election, they have to have at least 30% of the employees in the petition for unit. And the union, when it may file the petition for an election, is picking what unit of employees it wants to represent. So if there are 4 different types of employees at a facility, it can pick which ones it's trying to represent. And usually it's going to do that sometimes based on the nature of the union and the type of employees it represents, but sometimes it's going to do it and it's going to try to pick those areas where it thinks it's going to get the greatest support. Employees who are deemed confidential are excluded, as are supervisors. And so those definitions about what it means to be confidential and what it means to be a supervisor can be very important in this process. There's also generally, where an employer has multiple facilities, there is generally going to be something called the single site presumption that relates to whether a bargaining unit is across multiple facilities or the same facility. But typically, it's going to be one facility, and you could have separate bargaining units at each one, but there may be reasons why that would not be appropriate. For example, if there's a lot of interconnection and employees work between the 2 facilities regularly, and they're really sort of operated as one, and the geographic proximity can play a role in that as well. So when the union has a sufficient showing of interest, it can file a petition for election with the NLRB. And then there is a hearing that's held if there are objections to any of these issues. Sometimes there's just a stipulation and you don't actually have to have a hearing, but that hearing is the opportunity for employer to raise issues, to say they're trying to get supervisors, they're trying to get confidential employees, they're trying to put professional employees in the same unit, or other objections that it might have, or these employees aren't even covered by the Act because they fall under some other exception, or the unit is not appropriate for one reason or another. And then there is a hearing held on that, and after the determination is made on those issues, then an election is scheduled. And unions complain that that process of the employer raising these legal issues unfairly delays the election and gives the employer added time to try to influence employees against the election. So this, by speeding up the process, is attempting to limit the challenges. So the significant changes to the rules that are made with these ambush election rules, including having these pre-election hearings occur more quickly. So under the new rule, it could be as early as 8 days after the petition is filed, and when the employer is served the petition by the NLRB, they'll be notified of when that hearing is going to be. So that's not something the employer doesn't have to guess at the date. They're going to be notified of a hearing date. But when you're trying to have an evidentiary hearing, which is sometimes the case to try and prove, for example, that employees are confidential or supervisors or something else, that does not give the employer a lot of time to try to prepare for that hearing. And that's not 8 business days, that's 8 calendar days, with the day after you're served counting as day 1. So, depending on how that falls in terms of holidays or things like that, that could really only give the employer a few business days. And if it's an employer who's not prepared, who doesn't have experienced labor counsel in place, then you've got to figure out what to do with this. Get counsel up to speed, prepare witnesses, prepare your evidence, and have a hearing, which could all happen in as soon as 8 calendar days after you find out about it. So that really puts employers to the test to be able to prepare, and frankly, that's the point. Employers must also submit a detailed statement outlining the disputed issues, containing the preliminary information regarding the employees in the unit, and this has to be done the day before the hearing and circulated to the union. So basically, the union is going to get an advanced look at the employer's case. The employer, you notice that it's not both ways, right? The union then doesn't have to give it a response, so the employer knows what the union's evidence is going to be, what the union's claims are, so it's making it easier for the union to be prepared to defend against the employer's case and making the employer lay its case out. It is not a two-way street there. Issues of eligibility and inclusion in the unit will typically be deferred till after the election. So those issues that I just raised about, is this person a confidential employee? Is this person a supervisor? Instead of hearing them first, the board's going to say, we're going to go ahead and have the election, and we're only going to actually hear testimony about whether these individual positions or these people should be included if it would be outcome determinative. So if you have an election that was won by a very broad margin or lost by a very broad margin, the board won't even ever address those issues necessarily until after the election, because then they're like, it doesn't really matter. You can deal with it in other ways, or you can refuse to include them. There'll be other means, but they won't even decide that before the election. We'll say, well, maybe it doesn't matter. This rule also would eliminate the opportunity for briefing after the hearing, except in very rare circumstances. So now you have this hearing on these legal issues, sometimes which are very complex, and then there's an opportunity to submit briefing so that you can, for example, cite the law in support of your position, the typical reason why lawyers submit briefs. And that gets eliminated. Again, streamlining it, but also limiting the employer's ability to really present its case in advance of these decisions. And currently, you can request this regional director. So there's different levels within the NLRB. You can request a review, and under the new rules, requesting that review of the regional director's decision will not stay the election unless the NLRB, the full NLRB, decides to do that, which we would anticipate would be a very rare occurrence. Now, this is very troubling to employers for some of the reasons that I hope I made clear. So there have actually been 2 lawsuits that have been filed on different grounds to try and challenge this. The Chamber of Commerce, along with several business groups, filed a complaint in federal district court to stop the board from moving forward with the rule. It alleges that the rule violates both the National Labor Relations Act, which is the underlying law that the NLRB is charged with enforcing, and the Administrative Procedures Act. The Administrative Procedures Act governs the manner in which administrative agencies can do rulemaking, and they have to follow that. So basically they're saying that they didn't follow the federal rules, that it's not consistent with the National Labor Relations Act. Federal agencies have to act consistently with their governing federal statute, because their job is to carry out the statute, not to create their own authority, but to act within the powers that have been delegated to them by Congress, and that finally it violates employers' right to free speech and due process. Under the complaint, they suggest that the shortened time period impermissibly limits employers' rights to communicate with employees about unionization. The idea being that it doesn't give the employer really an opportunity to get to speak to its employees, and so in that way curtails their free speech rights, whereas the union could have had months or even years where they've been talking to employees about why they believe employees should unionize. The employer may not know about it. They get this petition, and then they have a very short window to try and tell the employees the other side of the story. Now, if you recall, when there was the debates going on about EFCA before ultimately legislative efforts to pass it died, that was one of the things that was the big complaint about it, is that employees would not get to hear both sides of the story before they had to make a decision. They were only hearing one side because at the time that you're asked to sign a card, employees only hear one side, and in fact, they may not understand the implications of signing a card. This doesn't go quite that far because there's still an election, but still the employees may have been hearing from the union for months, may only have an opportunity to hear the employer side of the story for a few days. The other case that was filed, which was filed in the Federal District Court in Texas, is the Associated Builders and Contractors of Texas. It was also the National Federation of Independent Business, Texas. And again, looking at the rule under this complaint, alleged that it makes sweeping changes in pre-election and post-election procedures that depart from the plain language and legislative history of the Act, meaning the National Labor Relations Act, and exceed the board's statutory authority. Again, so that saying you've gone beyond the authority that Congress gave you and you're acting contrary to both the intent and the language of the National Labor Relations Act, so therefore it is in excess of the board's authority. It also takes the position that the board provided no adequate justification for overruling years of precedent that preserved what they say is a careful balance of employer, employee, and union rights in the election process. Now, those cases were just filed, as you can see, within the past few weeks, and so therefore it's hard to know at this point what's going to happen. The rule is not scheduled to go into effect until April. At this point, it has not been stayed by the courts. That is certainly possible. In prior efforts by the board to change the election process through rulemaking, there have been courts, or there was also a notice that the board a few years ago had issued that employers were supposed to have to put up that basically was very pro-union in telling employees about what their rights were to unionize, and ultimately that was struck down by the courts and the board chose not to appeal it. So I think there's a lot more that's going to happen between, we're likely to hear between now and April on this issue. But we have to presume, until we hear otherwise from the courts or from the board, that these rules are going to affect, be that April 15th or at some other time. So this is the time, not waiting to see what happens in April, where employers really need to take proactive steps to be ready. Because as we talked about, this truncated time frame between the filing of a petition and the election itself is really going to limit an employer's ability to communicate with its employees regarding unionization. And so an employer is not going to have time to ramp up if it's not already prepared. So this is the time to take steps. So if you have non-union employees, first thing you need to do is to assess the vulnerability to union organizing efforts. If you know that there are unions who may be interested in your employees, or if you're in an industry that's heavily unionized, even if you don't know of specific unionized activities, if you are in a geographic area that is heavily unionized, you really want to be thinking about, if we had a campaign tomorrow, if we had a petition filed on April 16th, what would we do? How can we do things to be ready? So some of the things that employers need to be doing now is thinking about what those campaign messaging would be. Obviously, you're not going to write full campaign materials. I'm not saying rush out and hire a consultant, but think about what you would say to your employees. If an employee came to you and said, I'm thinking about, supporting a union, what are the kinds of things that you would be saying to them about why that's not a good idea, why that's not in the best interest? And just start doing little notes of talking points for yourself, thinking about who you would use to communicate with employees. And then on the issue of these legal challenges, start thinking about who are your list of employees that you would deem confidential. And confidential employees doesn't necessarily mean people in whom you generally have access to confidential information. It's very limited. Really, the confidential information that the board is talking about relates to people who have access to information that relates to collective bargaining. So, you may think of a far broader number of employees as being what you would deem confidential than the NLRB would, but you really want to look at that issue. Another key issue is who are your supervisors? And some people are obviously going to be easy, but those first-level supervisors in many organizations can be really a question about whether they're supervisors. And I'll use a healthcare example because there's been a lot of litigation over the years. In a hospital, you may have charge nurses. Are the charge nurses supervisors, or are they not? The difference is supervisors can't be unionized. They can't be in a collective bargaining unit, but people who are not supervisors, even if they may have some authority over other employees, can be. So where you have those first-level supervisors, things like charge nurses, things like working foremen, people who have some supervisory authority but also may work alongside, then you really need to look very carefully at whether you have a legal position that they're supervisors and what the implication of that. Things like I talked about, would a single site be appropriate, not appropriate, because you want to have been thinking about your answer on a lot of these legal questions and have those kinds of things ready. Who would your witnesses be? What documents would you need? So you can be ready very quickly. And then training, and this is a very important one. Training your HR people, training your first-level supervisors and your supervisors and managers on the ground. Because the problem is they're the people. The people who are on the ground are the ones who are going to get the first hint that you may have union organizing activity on. By the time it filters up, by the time you get the petition, it's really too late to effectively do this. And, in fact, you may also have another problem. If your supervisors aren't prepared and people talk to them about this and they don't know what they can and can't say, they may be committing unfair labor practices without even knowing about it. So you want to conduct training for your supervisors on how to recognize signs of union activity, what causes employees to want to unionize. Often it is not pay and benefits. Often it's issues related to respect, communication issues. If there's a supervisor who is not treating employees with respect, showing favoritism. Sometimes it can be something as simple as a very popular employee is terminated under circumstances that people don't really understand because, of course, you're not publicizing that, and it can create a groundswell of, we need somebody here to stop this, especially if you have somebody who has that been previously. So understanding what causes employees to unionize, understanding how to respond, what the signs are, and so for those first-level supervisors to, if somebody says something to them, what do they do? They can't ask, but what they can say and cannot say if somebody mentions them. If they, see documents laying around that may be suspicious, if they become aware of things, what they can and can't do about it, and then how you can start to be prepared to think about, okay, what would our campaign plan look like? Let's have that ready, and obviously details can be fleshed out. So these are all things that employers can and should be doing now to get ready in the anticipation that unions are also taking a wait and see right now because they know that it's going to be far simpler and require far less resources to try and organize in April than it does right now. Then, maybe they're going to take a little bit of a wait and see approach because, unions want to get employees organized using as few resources as possible. Organizing can be very resource intensive. Those resources come from union dues by existing members, but they want to try and do it in as resource light a way as possible. So if the NLRB can make it easier for them, they're going to take advantage of that. So you don't want to wait and suddenly say on April 14th, I guess I should think about this. So unless you hear that these rules are being stayed or they're being tossed out, you need to be preparing. So that's something that people can and should be doing now. And I'm now going to kick it back over to Bill, who I think was going to respond to a question.
Thanks, Shannon. We did get at least one question about some of the terms that I used when I was talking about Purple Communications, the email case and the confidentiality cases. And just looking at the slides from employees' use of email, I won't go back to the slides, but I'll tell you what I was talking about. One of the terms used in Purple Communications was special circumstances, that the board adopted a presumption that employer rules that ban or prohibit non-working time use of email are unlawful, that employers may rebut the presumption if they demonstrate special circumstances. Now, first, the board's presumption is that if you have a policy that says employees can only use email for business purposes, and that would therefore prohibit use of email for Section 7 purposes, that policy is unlawful. Employers can rebut that presumption if they demonstrate special circumstances, and the board, the majority opinion, did not give examples of what those special circumstances might be. The dissenting board members expressed some concern with the use of that term because they believed that it created a standard that would be very difficult, if not impossible, for employers to meet. So if you believe that you are one of the employers who might fall within the special circumstances category and therefore may be able to maintain a policy that prohibits all non-business use of email, you should talk to Labor Council, call your Labor Council and ask them to review the policy and talk about the specific circumstances that might put you, what might make you one of the employers that has special circumstances. The other term is also related to the email case, and that was something that it appears that this came out of the dissent but was adopted by the majority opinion, and that is that employers can limit the types of communication during working time and also monitor employees' use of email for legitimate management reasons. The message there is that if you have a policy, like many employers do, that informs employees that they do not have an expectation of privacy in their use of the employer's email, and that the employer has the right to monitor their email usage, you can maintain that policy. If you're monitoring their email, you can continue to monitor their email for legitimate business reasons. It's easier to tell you what is almost definitely not a legitimate business reason. If you believe that there is an organizing attempt and you therefore begin to monitor email more closely, that is probably a bad idea. If you are monitoring email for keywords like union or wages or salary, that's probably a bad idea. That the board, we believe that it's likely that the board would view that as discriminatory monitoring of email. If you are monitoring email to make sure that employees are using it appropriately, they are not emailing, exchanging inappropriate types of emails, obscene emails, harassing emails, other types of inappropriate emails, that employees are engaging in business relations, if they're communicating directly with customers or vendors, that those communications are appropriate. That is an appropriate use of monitoring employees' email. But again, the board was explicit that the monitoring cannot be used in a discriminatory manner. We recommend against beginning to monitor. If you think there's an organizing campaign, don't selectively monitor for words like union or salary or discipline or wage. And yeah, I can't see the question, Shannon. I'm a little farther back from the screen. Any other questions we want to address specifically?
Okay, so All right. Well, it looks like we are out of time. And so if there's any questions that we did not have an opportunity to get to, we will review them if you posted them through the Q&A, and we'll respond directly. Or if you have any follow-up questions, all of our email addresses are on the first page, and you can feel free to email any of us. Thank you again so much for joining us today. You will receive the webinar recording and the slides in a follow-up email. When you exit the program, you'll see a short survey on your screen, and we'd appreciate you taking a moment to complete it. Your feedback is very helpful to us in planning future programs. And speaking of future programs, we have a labor and employment law update year in review coming up on February 11th, which will be live in Philadelphia and will also be available by webinar. So if you have any questions about that, you can look for that invite on our website. Thank you very much, and thank you for joining us. Bye-bye.